Hey there. All right, now we're going live again. I'm excited again, talk about estate planning and what's going on. And that's the fun part about it is like what is, we keep talking about probate and why you should be worried about probate and what is probate, what's the big concern there and how can a living trust help you avoid probate. So a couple things that are exciting about this is as we kind of go through this process. First of all, a couple things you can tell. I'm a Padre fan, right over this shoulder, right? I'm also a Daredevil fan, which is up there. It's stuff actually the Daredevil, something my son gave me, and the Padres thing is something that my wife had made me. So I just want to spend a few moments today talking about, a living trust. How does it if you're worried about probate, and why should you be worried about probate if you're not? So probate. Let me give you sort of the bigger picture here. There's a couple things. When you pass away or you become incapacitated, somebody has to have access to your items. Okay, it's your stuff, whether it's bank accounts or residence, whatever you have, somebody has to have access to them. That's where probate comes in if you don't have a plan. If you're incapacitated and somebody needs to get access to your bank accounts, or let's say you're incapacitated and you own a home, somebody, and you need to sell it, like you can't afford it anymore, you're going into a facility. How do you do that? Or even rent it out if you want to earn money on it. Somebody has to be able to sign on the dotted line. And that dotted line on often is, something with title. Somebody has to be able to act on your behalf. In probate, if you don't have a living trust, what you end up with is you go to probate court. If you're incapacitated, you do a conservatorship. Okay, if you're deceased, right, then it's a probate. You do an estate. Someone petitions to be the personal representative. So that's where probate comes into effect when you have stuff. Okay, the other way probate comes into effect is, again, well, if you pass away without something in place, right? Somebody, right, has to determine who gets what. And what happens there is called intestate, which, is essentially just the state's way of figuring out who should get your stuff. Years ago, when my wife's father was an only child of depression kid, right? And his uncle was an only child, I believe. So when his uncle passed away, right, my wife's great uncle, when his uncle passed away, didn't have any, and he didn't have any children, didn't have any relatives, and so you have, kind of this convoluted way the attorneys handling the probate estate had to do essentially a large search to figure out who the heirs were. It turned out it was only my father-in-law, but you had to go back up to the parents and you go out from the parents to see if there's any other siblings of that individual. If not, you go further out and you eventually find somebody, but it can be a very cumbersome process. So if you pass away and you don't have any estate in place, that's the problem, right? You end up in probate and it could go to somebody you don't even know that well. Something could happen there. But the real key is why you should be worried about probate. Okay, and here's why. It's just cost. Cost, time, it's public. If you're incapacitated and you do a conservatorship, any major action, so if they need to sell your residence, for example, any major action would need approval by the court. Oh, and it gets worse. It's not just approval to sell, it's approval of the actual sell. You have to sit there and go back to publish it in a newspaper. Hey, here's the terms of the sale. Here's the hearing date. And you go back to probate court. Your Honor, is this okay? Can we sell it for this price to these people? That's the weird part about it. It gets very cumbersome, very problematic. And the other part is if you're incapacitated, you have to do and you get a conservatorship, you do an annual accounting. It's first year, and then after that, it's every other year. But it's cumbersome again. It's like a line item. Every single expense, every piece of income needs to amount to a big zero at the end of the day. You have to have it in the proper format. You have to submit it. You have to provide notice of everybody to everybody, so everybody knows. When I say everybody, it's within 2 degrees of sort of like nephews, nieces, down to that level, aunts or uncles. But everybody knows, hey, if you bought, depends that month, everybody knows that because it'll show expenses itemized with some details because you got to get it past the probate examiner who works for the probate court. Say, hey, well, what's this $35 expense here? So it's a very, very public affair. So the good news is you can avoid all this. You can avoid all this extraordinarily simply just by making an agreement with yourself. That's all you need to do. Put a contract together for yourself. Change your assets from you as an individual to you as a trustee. So let me tell you how it works, okay? So again, we'll start with the big picture. It's probate assets, non-probate assets. Non-probate assets will do the easy one, are things that are like contracts, 401ks, just an agreement. Bank accounts don't have to be probate assets, right? They generally don't have title. You can do payable on death, right? Retirement accounts, life insurance, things that can just transfer to a beneficiary. So if you have a life insurance and it goes to spouse typically first and then children as secondary beneficiaries, right? You pass away, they submit a death certificate, boom, funds are paid. No reason to go to probate over that. 401k, same way. Boom, could be paid. Here's the beneficiary designations. There could be some tax implications and some reasons to maybe do something different, but we'll put that aside. They just go boom, boom, boom. Get it out. Banks, you can put payable on death beneficiaries, right? Which works great if you pass away, right? They can get those non-probate items. Okay, probate items are like a residence, right? A boat, a vehicle, individual stock in your name, anything that has a title that if it wanted to be conveyed, someone has to sign. So that's your world, probate and non-probate. Okay, and that's when you pass away. Clearly, a beneficiary designation does not help that individual get access to your bank account. You never want to put them on your bank account. Many reasons. Number one, you say, well, that's just convenient and easy, right? They can write checks, they have access. Well, here's a couple things that can happen. One is, if they have creditors and they have some sort of issue, guess whose account they can go after? Your account. So they were like filed for bankruptcy, something to that effect. The second part of that is, I've seen this a lot where there's actual dispute. Someone says, well, mom or dad put me on there because I was taking care of them. Right? That's my money, when your intent may be to just put them on there for that convenience. So that's sort of the second part of that, is you just got to be careful. It's not a great way to. If you put them on the title to your house, right? Guess what could happen? First of all, it's a gift. There's equity in the house. It's a gift. And if it exceeds the annual amount, right, which I think is like $17,000 in 2023, I think that's what it is. If you exceeds the annual amount, well, guess what happens? It's a gift above that. So you do have to put on, you have to file a return. There probably won't be any taxes on it because we have a huge credit lifetime amount we can give, right? But still, it is a gift. It is a gift. And then guess what? They're on the title to your house. Same problems. Creditors, right? Maybe even a divorce. Is it community property? Is it not community property? Okay. And it doesn't really solve a lot of problems. There's still things they would have to do to get you off the title to the house. Okay, so now I've created some problems. Share of stock, same thing. Your name's on it. Who's going to sign? So that's the world we live in, probate, non-probate. If you're incapacitated, again, and someone needs access to your bank accounts, it's going to be very difficult to get. Okay, now the solution is very simple. Again, make a contract with yourself. Change it from one hand to the next. This is you holding it as an individual, or you and your spouse, to you and your spouse now owning it as trustees of your living trust. Okay, so the way that works is you create a living trust. There's some certain essential elements in a living trust. Okay, first of all, you need a grantor, somebody who's doing it, and that would be you and your spouse, whoever it is, right? Then you need a trustee. The initial trustees are going to be you and your spouse, right? Nothing's changed. You're still in control. You're still in everything, right? Then you need a written agreement. Okay, that's where I come in. Put it together. Here's the agreement. Let's make sure it meets your needs. So now you have those. Then you need a beneficiary who ultimately is going to get it, right? Initially, the way we draft these typically is, it goes to the other spouse. Anything left over goes down to the children. So again, nothing really changes from what people typically want to see, right? And the last part is you need property to put into the trust. You can create all four of those, put no property into it, and boom. Is it a trust? Court will have to decide whether it's a valid trust, okay? We have a few tricks to get there. We call it the magic wand. Hey, we're putting $10 in this trust. That would create a valid trust. But it doesn't help with those other things. So we create a living trust. We got the 5 things, right? dealing with the probate property. And if you're incapacitated, the non-probate property, such as bank accounts. We're leaving 401ks because, again, all those things have beneficiary designations. We just want them to sit there. When I say non-probate is important for a trust, usually like bank accounts. So now you're incapacitated, right? Something happens to you, it happens to your spouse, happens to both of you. Your successor trustee, who you get to name, not the court picking a conservator, right? It's not the court picking somebody to make decisions. You get to name them. And you can say, hey, if they can't do it, let's name the second person. So you get 2 or 3, chances to name different people who you want, who you trust, somebody you believe will carry out your desires. Okay, that's the cool part about it. Okay, you get to pick that. You have the ultimate freedom. So you get to do that. 1, 2, 3. You're incapacitated. You and your spouse are incapacitated. Your successor trustee can now come in. Okay, houses in the trust, vehicles in the trust, bank accounts are in the trust, all the funds are in the trust. You're incapacitated. They can step in as a successor trustee, go to the bank and say, hey, they're incapacitated. Here's a letter from the doctor. Very private. Here's a letter from the doctor in court, which you'd have to do with the conservatorship. They go to the bank. I'm the successor trustee. The bank account is for the trust. Now I have access to those funds. You cannot do that if you don't have the bank account in the name of the trust. You can't do that. The bank will say, no, you need to go get a conservatorship. I don't care if you're the successor trustee. I don't care if they said they want you to do it. It doesn't say it in a legal document, but a trust benefits that. Okay, now if your house is in the trust, you've moved out of it, right? You're in a facility or you're living with a child now, which would be better, maybe better in your situation. You're living with a child. Your successor trustee can now say, hey, the house is in the trust. Go and sell it. No publicizing it in the newspaper, no having to go to the judge, begging for permission. They can then sell the residence, pop it into the trust account, and now you have access to it all without any court intervention in it. So that's if you become incapacitated, right? Sell the vehicle, it's all in the trust. Very simple to do. And again, you're just creating a contract with yourself, going back to those 5 things. You're the settler, you and your spouse, or you are the settler. You're the trustees, you're making the decision, or you get to appoint successor trustees, right? You have, it's written in a document, right? You have beneficiaries, there's going to be you initially, you and your spouse, and then children ultimately, and then you have property. We put it in the trust. That's the benefit of it, okay? So we can avoid any sort of court on the conservatorship side if you become incapacitated. And I want to be clear, the trust we would typically draft it would say, hey, you're incapacitated if you get 2 letters from doctors. So your successor trustee just can't go out and say, well, yeah, of course they're incapacitated. We define that. And so therefore, if something does happen, the bank, the real estate company, whoever it is now saying, are you truly the successor trustee? Do you truly have authority? They can then go in, look at it, and be like, yes, you do. Here's the trust. Here's where they appointed you. Here's the documentation that shows they're incapacitated. We're good to go. Okay, very streamlined. Now, when you pass away, it's just as streamlined, right? Everything's in the trust. Successor trustee comes in and does what's called trust administration. Okay, trust administration means they gather all the stuff together, called marshaling the assets. Put all the assets together. Once they have the assets together, they pay off all the, death or whatever other creditors are out there, death expenses, whatever other creditors are out there. Then they get a net sum. And then with that net sum, they can sell the residence, sell the vehicle, whatever it is that if you directions are in there, or if you left it to their discretion, take those proceeds and divide them up. No court, nobody's permission, just following the directions that you put there. Okay, and the beauty of it is this. When it's in the trust, they have time to do it. Okay, if it's not in the trust, let's say there's a mortgage or a reverse mortgage on the residence, right? And they have to sell it. Now they got dealing with a creditor saying, hey, where's the money coming from? Make those payments. We heard they decided. Everything's going fast. Now, instead of taking the time to process through the death of a parent, a spouse, a loved one, right? Instead of processing through that time, as they would have time to do in a trust, they are now dealing with creditors. They are now dealing with a probate process. They're now dealing with a probate attorney. right? And dealing with all that stress that goes with it. So instead of having time to properly process and mourn, they have to jump into how do we get this done. With the trust, you can gather those assets as quick as you can or as slow as you can. Every situation is slightly different, but it would be great if your children, your trustee, have that option, and they're not suddenly getting notices from a court saying, "Hey, there's a hearing on this date. You can appear or not appear. If you object, file an objection." Right? All that is taken care of by you through the simple idea of just creating a living trust. Living trust is revocable. As long as you have capacity, it can be amended, can be changed. Assets can be moved in and out. You can terminate the trust. As long as you have capacity, you and your spouse have capacity, or you or your spouse have capacity, you're free to do what you want with it. That's how a living trust really kind of gets you out of a concern that, hey, who's going to take care of my affairs? I've heard friends of mine who will say, the kids will figure it out. And I keep going, no, they won't. Because the hardcore reality is, if you become incapacitated and you have money in a bank account that you need access to, it's tough to get at. Tough to get out without a court order, and that means a conservatorship. If you pass away and you own a residence, now we're in probate, but still in your name. And from my profession side, thanks to the California legislature, attorneys get a lot. We get a percentage, 4% of the first 100,000 of gross value, 3% of the next 100,000, then 2% of each 100,000 up to like 750,000. So really, those fees are just going to add up and add up and add up. For $1 million estate, and that's gross value. You could owe 500,000 on that. Court doesn't care. It's $1 million of gross value. Right? For that $1 million of gross value, a probate attorney is going to earn a sizable fee of somewhere 15 to 20,000. Right? And so you're not doing any favors by not having a living trust done. So it gives you peace of mind. It gives, like if you become incapacitated, it gives your children peace of mind. And it saves you the hassle of having to deal with all this stuff. I mean, no one wants to be, and I've seen this, I've been there. No one wants to be wheeled into court when they lack capacity and deal with those types of things, where the judge is asking you questions, where you have an investigator come into your house. Nobody wants to force their loved ones to be sitting in a court hearing 45 days after you pass away, trying to figure out what's going on. Okay? Living trusts are very simple vehicles. One hand to the other. You transfer it from yourself, right, to yourself as a trustee. Still have all the same rights, control, power, everything. That's a good thing about it. And if you're concerned, if you're concerned about that's your second or third marriage, right, and you're concerned about the children from your first marriage, and your spouse is concerned about her children from the first marriage, we can fix all that inside the confines of a trust. So you have very specific parameters. It's like, hey, this is what we're going to do when it happens. It's the intelligent thing to do. It's the kind thing to do. You don't want to leave it up to a judge, and you don't want to leave it up to children after the fact. It's just, when a trust says, hey, it's 50-50, it's 50-50, right? Trust says, hey, my child one is making all the decisions, going to be child one making all the decisions, right? And if child one can't do it, it's child two. You end up in court, child one and two may be saying, no, it should be me. I'm the one who was closer to mom or dad or to both of them. They always trusted me. Court has no direction. So now your children are fighting against each other, banging heads. And both of them could think perfectly right. Hey, this is the way they would have wanted. And they, based on this conversation or that conversation or a feeling, right? Assuming good intentions here. And so by creating a living trust, specifying, we can, do all sorts of things. So that's why for me, when I say, are you worried about probate? You should be worried about probate, but I'm not saying that without a solution. That solution is clearly to go get a living trust, and get it done right, get it funded, right, properly. Because remember, as I said, without property in it, right, trust isn't really good, right? You need that fifth element of property. But if you're incapacitated and there's nothing in it, that property is not inside the trust, how are you going to get at it? That's why it's important to be comfortable that you get the right trust at the right time with the right person. So worried about probate? Yeah, you should be.